Moorish sovereign citizens is the first clip I got for y'all today. For anybody that doesn't know what exactly a Moorish sovereign citizen is, allow me to enlighten you. The Moorish sovereign citizen movement is a collection of independent organizations and lone individuals that emerged in the early 1990s, which believes that the individual citizens have sovereignty over and are independent of the authority of federal and state governments. They use their perceived immunity for things such as refusing to pay taxes, buy auto insurance, and register their vehicles. And the list goes on, ladies and gentlemen, but I'm not going to go into depth and details on this group. If you want to get into it a little more, go ahead and Google it. One more quick thing before we get into this clip, ladies and gentlemen. There's a little blur that pops up here and there. Hopefully it doesn't trigger nobody.
And Cheyenne M. Cushing-Muriel, would you state your name for the record, please? Your attribute for the record, please.
Cheyenne M. Cushing-Muriel.
Alright, gotta stop it already. Gotta really pay attention to the words in the courtroom. The judge opened up and said, "Can you state for the record your name, sir?" Oh, wait, hold on. I mean your attribute. Because you know a lot of these guys, they don't go by a first and last name anymore. I showed y'all that clip from Canada the other day, and the guy got into an argument with the judge just because he wouldn't agree to accept his first and last name. He said, nah, man, my name's just Kyle. Kyle, that's it. My daddy gave me that last name. I didn't ask for it. But a lot of these individuals do take on new names, and the judge is just checking her ends by saying your attribute. Because she already knew it was coming. I'm sure she's already been informed by a few judges about this dude.
And Cheyenne M. Cushing-Muriel, would you state your name for the record, please? Your attribute for the record, please.
Cheyenne M. Cushing-Muriel on behalf of the Marrakesh Empire Aboriginal Law.
All right. I want to ask you a couple of questions, please. The first question I want to ask you is, are you employed?
Objection, man. This hearing is supposed to be about jurisdiction. This court has no jurisdiction. The court has no jurisdiction to determine its own jurisdiction for a basic issue in any case before a tribunal.
Well, if I have no jurisdiction to determine my own jurisdiction, how are you going to get that issue resolved?
Already getting some objections out there. Just a couple seconds into it and we're getting objections. She asked if he's employed, making money, or whatever the case is, and he goes, she has no jurisdiction to be asking that.
Listen, this case in this courtroom is a culpable, incompetent court of jurisdiction. You can't, according to federal case law, you can't set another hearing to reach and determine your own jurisdiction. As I've stated for the record plenty of times, I'm only handling threat, duress, and coercion, and because the prosecution falsely holds my property, and I'm here to clarify that matter. Other than that, I'm here under threat, duress, and coercion. It is completely against federal case law. It has power to act, and the court must have the authority to decide that question in the first instance. That's Rescue Army versus Municipal Court of Los Angeles. A departure by a court.
You see the guy in the background, man? He's like... all this stuff he's saying just because she asked if he's employed. He's going into depth and detail why she has no right to be asking if he's even employed at all. And I mean in depth and detail, if you can't tell already.
Established requirements of law, however close apparent adherence to mere form and method of procedure, which has the effect of depriving one of a constitutional right. It's an excess of jurisdiction. You have the flag right behind you, ma'am. May
I interrupt you for a moment,
You may not, ma'am.
Then would you, when you're done...
You may not interrupt me, ma'am. Objection. I swear, y'all, if I ever have a petty ass, oh, actually I do. I got to go in front of the judge in a few days. As a matter of fact, I'll be representing myself. I might have to throw out a few objections. And the judge is going to say, "Why are you objecting, sir?" "Your Honor, I've always wanted to do it."
When you're done speaking, would you let me know so that I can ask a question?
I'm not obligated to answer any questions, so I have no intentions of answering any question.
Well, I'll ask it anyway, and you can decide what you want.
So he's pretty much there just to speak, and the judge is supposed to just go with everything without asking any questions. He's not obligated to answer any questions. I mean, no one really is, right? And look at that guy in the back, that grin right there. He's enjoying himself. He's like, man, this is the best court session I've ever seen.
Of the subject matter on which it assumes to act, its proceedings are absolutely void in the fullest sense of the term. Dillon versus Dillon. Courts enforcing mere statutes.
He's bringing other cases into play. Dillon versus Dillon. That is a really good thing to bring into the courtroom, is other cases, you know, that kind of back up your situation. But I don't even know if this is the time and place to bring it up yet.
As it is to my understanding that this is a statute and not a constitutional violation of law. In fact, one of the hearings I had with you, you said people are not charged with constitutional violations. I don't understand how you could be enforcing statutes and you have the U.S. flag behind you, as if you hadn't taken an oath to uphold the Constitution. Courts enforcing their statutes do not act judicially, but merely ministerially. Thus, no judicial immunity, and unlike courts of law, do not obtain jurisdiction by service of process, nor even arrest and compelled appearance. Boswell versus Otis. I've been here 3 or 4 times on the threat, arrest, and coercion. Prosecution doesn't even have folders in front of him. He has no objections. He has nothing to say. He cannot prove jurisdiction. This court should have been dismissed this case. This is a colorable court of incompetent jurisdiction. That fact is circumstance to be considered in determining whether the first instance there was a probable cause for the arrest. Monroe versus Popper. There is no discretion to ignore the lack of jurisdiction. Court must prove on the record all jurisdiction facts related to the jurisdiction asserted. A universal principle, as old as the law, is that proceedings of a court without jurisdiction are a nullity and its judgment therein without effect either on person or property. This case has already been put before the federal court and you will be receiving a notice of removal very shortly. This court has no jurisdiction. Prosecution can't prove jurisdiction. This case shall be dismissed, and it will.
So yeah, if he's going to be going to a federal courthouse, I guess he really has nothing to say here. It could go against him in the courtroom later on down the road when he goes to the federal courthouse. But the way he's presenting everything, man, I can't keep up with it. I'm not a damn, I didn't go to law school. I just been sentenced to jail and prison a few times. I mean, yeah, I've learned a few things going in and out the courtroom, but some of this stuff this guy's saying, it's so fast, I mean, I can't even keep up. But it seems as though this guy's doing pretty good in the courtroom today. What do y'all think so far? Let me know in the comment section below.
File a notice of removal with the federal court?
Yes, you will be receiving it shortly.
All right. Well, when I receive it, I will rule on it. This is my question to you, however. Are you employed?
I'm not employed. I'm not employed with any,
She went right back to the same damn question. She went right back to the same question. She has some nerve. Oh man, he's mad. She's stirring the pot, ain't she? You see how she took a long pause after she said, can I ask you a question? Because the first time she asked if she could ask him a question, he went into objections and then this whole speech. So she had that long pause to make sure he wasn't going to go into another spiel. But god dang that judge, she went right back to the same question. Can you believe that? Are you employed?
Of corporations incorporated with the state of New Jersey.
Are you employed with any corporation that's incorporated outside of the state of New Jersey?
Objection. I'm not here to answer questions about my employment. The last time I was made aware of this was supposed to be about whether this court has jurisdiction, and clearly it doesn't. A question about employment has nothing to do with whether this court has jurisdiction, so I'm not obligated to answer those questions.
If you were to say he does work for a corporation inside the state or outside the state, she might be able to say she has jurisdiction. I don't know. She might be trying to lead him into a different path that he's trying to take. Or she might not be trying to lead anywhere with the questions at all. But he's still in defense mode saying that this has nothing to do with anything on why we're here today.
No, I shall not be answering any more of those questions that are not pertaining to jurisdictional facts.
Well, this is my question to you. I asked it before. If your position is that this court has no jurisdiction to determine its own jurisdiction.
That's the objection, man. That is not my ruling. That is not my holding. I've given you the federal case law regarding such. Maybe you can take some time out that you need to do to recheck that, but that's what the case law says. It's not what I said.
Well, I do have jurisdiction over you. Number one, you're here in my courtroom.
Objection, ma'am. You do not have jurisdiction over me. I'm here by way of threat, duress, and coercion. The case law stipulates already that compelled appearance and arrest warrants doesn't give a minister acting ministerially and not judicially enforcing their statute's jurisdiction. That's incorrect and false. You do not have jurisdiction because I'm here. You've told me before when I was here that you would lock me up if I didn't come, which was threat, duress, and coercion.
This guy knows a lot more than some of the clips I've seen. This guy ain't doing too bad in the courtroom, I'm not gonna lie. You know, law is fascinating, man. Every time I watch these clips, it makes me want to learn more about the law. I've been reading a lot into, lately, maritime law. That's something deep, ladies and gentlemen. Go Google it.
I think that you misstate what I told you.
Objection, ma'am. I have not misstated. I have the videos. I have it on repeat 24/7. I've seen you say it.
I don't recall that I said I would lock you up.
Well, objection, ma'am. That's on the record.
Well, you can object all that you want, sir. And I will continue to have a difference of opinion about that. All right. Well, we'll continue with today's proceedings then. And I certainly appreciate the courtesy that you extend to me.
She seems to be getting a little agitated, but she's checking her ends and she's being respectful at the same time.
Let's talk about the issue of, Mr. Walker, I want to talk about the issue of jurisdiction. One of the issues that has been raised in this case and has been raised over and over again that really needs to be determined before we can proceed with it is with regard to jurisdiction.
Yeah, she knows she can't move forward with anything, unless she has jurisdiction.
I have received, that was filed with the court, it was received in my chambers on January 7th. I'm not exactly sure if it was filed downstairs on a different day. Something that has been entitled a non-negotiable affidavit of fact to dismiss with prejudice for lack of personam jurisdiction, lack of discovery, and lack of an injured party. It purports to raise the issue before the court of lack of jurisdiction with regard to Cheyenne Mutada Kushmir L. Despite what Cheyenne Mutada Kushmir L says, this is not an application to the court to dismiss anything with anything. There are certain ways, as you are aware, Mr. Walker, to bring issues before the court. What we need to do is have the issue brought before the court properly by way of a notice of motion. I don't even know if Mr. Luciano got a copy of this, but certainly you know that any motion filed has to be served on the prosecutor. How much time does your office need in order to do that? And did you receive a copy of this?
Judge, I have not received a copy of that, and before I address that issue, I would respectfully request that you inquire into this defendant's assets to see whether he has a present ability to retain private counsel.
Objection. This is obscene.
Sir, this is a conversation that I'm having with Mr. Walker, not with you.
And
the way you didn't want me to interrupt you, I would like you not to interrupt me or Mr.
It's a conversation about him, though. Right? Shouldn't he have the right to say something if they're conversing about him? Especially in the court of law?
Mr. Walker.
Objection. This man cannot speak for me, man. I hadn't filled out any public defender's applications nor contracts to agree to that. You cannot force me against my consent to have someone who I had no formal contract or agreement with to speak on my behalf. I'm a natural flesh and blood man. I don't have to have, yes ma'am, I do not have to have an attorney at law, a colorable attorney at law, de facto attorney at law propose or purport to speak for me in any regards to these matters at hand.
March 23rd, sufficient time, Mr. Walker?
I think so, Judge.
All right. Then this matter shall be and hereby is continued until Monday, March 23rd at 9 o'clock.
Objection, man. The notice
He's objecting to continuance.
the removal's already in. You will be receiving it today. So,
If I receive it before March 23rd at 9 a.m., I am aware of my obligations when a matter has been removed to federal court. If for some reason the federal court does not accept it, or it's not properly filed, or there's something else, that's the next stage for this proceeding.
objection, man.
See how she had to throw in, or it's not properly filed? Come on, with the low blows, Your Honor.
I will not be participating in any more of these proceedings.
Oh, shit.
Do what you want.
I'm sovereign. I can do that.
This is the only notice that I will give you of the proceeding on March 23rd at 9 o'clock in the morning. We don't send out letters reminding people. We'll simply expect that you will be here. Thank you very much.
He will be contacted by my office, and we'll arrange an interview with him in the office, and he'll have to sign in.
Do you have his address?
It's
on here.
How dare this guy? He has some nerve. This court-appointed attorney's just trying to stir up the hornet's nest now. We'll get him in the office. We'll get all that stuff, Your Honor. Don't worry about it. This guy's looking at him like, you will not get me in that office, man.
It's
the
on
only
here.
address I have is the
P.O. box is right here.
Objection. If you attempt to contact me and negotiate any contracts with me, you will be getting sued in federal court too as well, sir.
All right. Thank you very much.
Honestly, let me know in the comment section below how you think this guy did in there. Did he give him a run for their money? I mean, if he knows for a fact it's going to a federal courthouse, then there really ain't no need to say anything in that damn courtroom.